All right, I think we can get started here. Welcome everyone to our webinar on the new process to protect undocumented whistleblowers, or otherwise called non-citizens. I'm Kimberly Best Robidoux, a partner with WR Immigration. We are a law firm that is dedicated to working with employers and individuals journey forward with their immigration process. And we are happy to be here today to talk about one of these new processes. Kick it over to Josune. Would you like to introduce yourself?
Yes, thank you. My name is Josune Aguirre Gamez. I'm a senior associate here at WR Immigration. I help, like Kim said, U.S. employers and individuals with their journey here in, the U.S., but we also have a global section as well.
And good morning, everyone. My name is Hieu Williams. I am not with WR Immigration, but I partner with them. I am a partner at Hirschfeld Kraemer. We are an employment-based law firm. What that means is I defend employers, supervisors, HR professionals from claims brought by current or former employees relating to, sexual harassment, discrimination, retaliation, all that fun stuff. So that's what I do. I also, in addition to litigation and defending employers, I partner with the employers to help them develop sound policies and procedures to avoid lawsuits.
It's always good to avoid those.
Yeah.
All right. So this legal disclaimer, right? This does not constitute legal advice. It's for informational purposes only. If you have questions or want a legal opinion, you can schedule a consultation with any one of us. So we're happy to help out there. And we just went a little bit about the firm. Like WR Immigration, as I mentioned, is throughout the US, and we do work strictly with immigration law. So we always love to partner with Hieu, who focuses on the employment law, that stuff that we don't get our hands dirty with because it's super complicated. Right. So we're going to talk today about the US Department of Homeland Security, their new initiative. Right. So to give a little bit of history, in October of 2021, the Department of Homeland Security issued a policy statement, and that was called Worksite Enforcement, the Strategy to Protect the American Labor Market, the Conditions of the American Worksite, and the Dignity of the Individual. One of the things in that memo did was it said that the government was going to focus on unscrupulous employers, right, in their pursuit of worksite enforcement. Flash forward a little bit, and in January of 2023, just this year, the U.S. Department of Homeland Security announced an initiative to extend more protections against deportation for undocumented individuals who can speak out about labor violations without fear of retaliation process or without fear of retribution. They've created a legal process for whistleblowing by undocumented or non-citizens to be able to speak out about labor violations. And Department of Homeland Security has provided this labor process to defer removal from the US for individuals who are non-citizens or undocumented to be able to complain or provide a valid complaint to a labor agency that there are unsafe working conditions. And this process that we're now seeing actually start to happen has been something that will allow those individuals to be able to stay in the United States in a legal status for up to 2 years, and there also will be eligibility for work authorization. So with that, let's kick it over to talk to Hieu about, what do employers need to know as we kind of journey through this whole new process?
Thanks, Kimberly. So, as Kimberly said, an employee who works for a company but is undocumented or a non-citizen, so is in the United States without the appropriate paperwork or authorization to work, they may speak out or choose to speak out about either things that they think are unsafe or unlawful, and what they would get in exchange if an investigation is opened into the employer is deferred action, the fear of being deported. And in addition, they could get the benefit of actually getting legal authorization to work. And so what do employers need to know? Well, first and foremost, you should, and if I were your employment lawyer, I would tell you to comply with all the laws that relate to your organization. So that means federal, state, and local laws That means making sure that you're following OSHA and Cal OSHA regulations, that you have the appropriate eye washing stations, you've got the appropriate signage, and you have the appropriate licensing from an actual like physical safety standpoint, right? In addition, there's going to be laws that relate to wage and hour claims, and you're going to want to make sure that you're paying people appropriately under state and federal law. And then there's, any host of other specific laws related to whatever industry you're in. If you're in the medical industry, there's going to be laws that relate to that you're going to need to comply with. So essentially, an employee that is undocumented or a non-citizen could raise a concern to any one of the government agencies related to any one of these laws and say, hey, I think that my employer is not following the law. And what they get in return for that is potentially deferred action. And what the Department of Homeland Security is doing is now streamlining that process. So this was technically a process that was always in place, but now they're really highlighting it and saying, if you're an employee and you go to, let's say, for example, the California Department of Labor, and you say, I am not being provided my meal periods and rest breaks, or I'm not being paid minimum wage, or I'm being owed overtime, you can go to the Department of Labor and bring that complaint. Ask for the government to look into it, get them their back pay or whatever it is they're owed, and then say, oh, by the way, I'm undocumented or a non-citizen. And then that government agency will go to the Department of Homeland Security and submit a request. And Josune will talk about this in a minute, to say, hey, can I get deferred action? So what employers need to know is this changes what I call the game a little bit. A lot of people might not have come forward before employee-wise because of fear that they would get deported, right? That's the public policy behind this, is that these is that the government wants to, as Kimberly said, root out these corrupt or unscrupulous employers who have, let's say, the proverbial sweatshop, and say, look, you can't do this to people anymore. And there's no more fear of deportation. So if you're a bad employer per se, you wouldn't be one of my clients, but if you were, and you're threatening somebody and saying, well, I'm going to pay you below minimum wage and there's nothing you can do about it, because if you come forward, you're going to get deported, not me. So now the word is going to get out to these employees that, hey, even if you're undocumented or a non-citizen, you can actually benefit from filing a good faith complaint against your employer. So that is what employers need to know, I would say.
Thanks. So Hieu, what government agencies are we looking at that are going to be involved in this process? As you mentioned, they already are, but now we're going to have a streamlined process and one that has more awareness than we've had in the past.
Exactly. There's so many. I mean, I named a couple first that, for example, I named OSHA. And then there's also the mini Cal OSHA, but any local, state, and federal labor agency that you can think of. So they could go to the Department of Labor, the Department of Industrial Relations, and complain about an unsafe working environment or failure to pay wages, things like that. They could go to already the former Department of Fair Employment and Housing, now called the Civil Rights Department, which is a California agency for, a claim of discrimination, harassment, also like retaliation and wrongful termination, and the federal counterpart to that, which a lot of people already know about, as the Equal Employment Opportunity Commission. So it just has to be some sort of government agency, either at a local, federal, or state level. And then any one of those agencies can basically go to bat for the employee and submit a request to the Department of Homeland Security.
So I know the whole public policy about this is to streamline it so we can open, investigations even further, but it does require a lot of moving parts, including these agencies, to cooperate with streamlining the process as well. So what does it mean? I guess what would it look like? So an employee, goes to an agency, files this complaint or files, some grievance, and then what does that look like from there?
So essentially the person would have to work with that, whatever local agency, state or federal, that they've submitted the complaint to. They'd have to actually say that they were undocumented or a non-citizen, give them information that, actually supports a claim. So the allegations, they'd have to provide identification for themselves, saying who they are to prove, identity. They have to provide any documentation that they use to get into the country. And And then what happens is then that labor agency would then submit a statement of interest on their behalf, asking the Department of Homeland Security to take action, saying that there is a government interest in keeping this person here and in trying to investigate the allegations against the employer.
Yeah, so the time frame, though, I think is quite interesting, right? What from the time that they filed the complaint as to the time that Department of Homeland Security gets the statement of interest.
You're right. So while we say it is streamlined, someone can make a complaint against you depending on the statute of limitations. So if this is a wrongful termination or sexual harassment, discrimination claim, a person under at least California law would have at least 3 years to do that. And then let's say you fired them, today, and they think it's based on their gender or their race or their age. They could wait 3 years to come back and sue you. And then after that, they could report it to one of the government agencies, in this case, the Civil Rights Department or the EEOC. And then from there, then it would, if that local agency or federal agency decided to fill out a statement of interest for you, then supposedly in 3 days, the Department of Homeland Security is supposed to take action. But again, it could be anywhere up to 3 years. If it were a labor claim, like a failure to pay wages, overtime, inaccurate wage statements, waiting time penalties, that a person could file today if they wanted to. They have up to 4 years to do so, but they could do it today. And if they did it today, if the local agency were actually to pick it up, it could take anywhere between 6 months to a year before they actually investigate. So again, it can take a really long time, and that fluctuates depending on how overburdened these agencies are. But once they take interest in the case, then it should move rapidly. Thank you for that clarification, Josune.
No. Okay. I think we can
And then do we want to talk about from the immigration perspective, right? With the statement of interest, once the Department of Homeland Security comes back and says to that labor agency, yes, we agree, we sign off on the statement of interest, that agency will then give the statement of interest to the individual, to the employee, who then files through the Department of Homeland Security, pretty much through USCIS, United States Citizenship and Immigration Services. Or if they are already in some kind of court proceedings or removal deportation proceedings, they would file with ICE, Immigration and Customs Enforcement. But what that individual employee is now doing is submitting a request for this deferred action and for, in most instances, work authorization card. Deferred action is kind of this, phrase that gets tossed around. We hear DACA all the time, and I don't think a lot of people understand that it's actually deferred action for childhood arrivals. There are a lot of individuals that may be in a situation where they have deferred action. And the question that that we usually have, some immigration attorneys who don't deal with deferred action all the time, but people who aren't in our industry are like, what is this deferred action? I understand, what does this mean to the employee? And why is this something that they feel that, hey, if I come forward with a claim, I'm going to be able to get deferred action, and that's going to help me. So Josune, how would that help somebody? And what is this thing called deferred action?
Yeah. So deferred action is the government using its discretion to hold off removal or deportation of an individual. And, sometimes it may be worth an individual who may not be in the system yet to file this and be kind of in the system and have this deferred action granted to them, because with that, they're able to apply for work authorization. And with the valid work authorization, they're able to go to Social Security and get a valid Social Security number. And this could be huge for an individual, right? And I think that's where it gets really interesting in the dynamic between an employer and a employee or former employee, right? Because then negotiating, right, Hieu, like before, I think employees were able to negotiate with different, avenues, and now there's deferred action in the mix, right?
Yep. So, and this is again one of these game changers, in that before, say as an employer, you're not perfect. I've never met an employer in California that was perfect and was able to follow every regulation. Otherwise, I wouldn't have a job. But say you accidentally didn't calculate their overtime correctly, or you didn't provide them with their meal period if they're a non-exempt hourly worker with their meal period by the end of the 5th hour, whatever it is, some hyper technical law that you did not follow for one reason or another because you didn't know the law or changed on you, etc. But before, an employer might be able to see counsel and say, you know what, look, it's easier for me to settle this claim with this person, so everybody can move on with their lives and you get a full release. And the employee and the employer, I think, stood to benefit from that because the employee wanted money and could walk away, and they would be giving up their right to sue you. Now, though, if you add deferred action into the mix, an employee or former employee isn't going to be as motivated to settle for a certain amount of money, right? On the one hand, I make a complaint and I say you didn't pay me correctly, or there's, I complain about you, you're going to get the citation, and the employer offers money. On the other hand, they don't take the money, but now they get something far more valuable, which is, legal status to work in the country for a number of years. It's not even, just 3 months or 6 months. It is up to 2 years and then could be extended, right? So again, the risk reward is so much higher for this complaining employee to make the complaint. And the scary part is, and what I have concerns about as an employment lawyer, is there, I do see what I believe to be meritless complaints. And so something like complaints. And so something like this, deferred action, could motivate somebody to bring fraudulent or claims that lack merit against an employer, just because it will allow them to stay in the country for a little bit longer.
Yeah, I do want to clarify. So deferred action doesn't give lawful status, but it allows them to lawfully remain in the US. So huge technicality, but I think that's something that individuals need to balance as well. Do they want to proceed with this because it is temporary? It's a temporary, benefit that just prolongs potential removal, right? But it is great in that you get work authorization and all these benefits. So,
right, and it also can allow them to stay in the country a little bit longer, to be able to hopefully identify some other avenue through which they might be able to gain some type of lawful status to remain in the US. So they do have, that's something that they can consider. But the other thing that I was thinking about is that these agencies, also need to say to Department of Homeland Security, is this somebody we want to advocate for, right? Is this a significant enough worksite violation that we want to say, let's protect this whistleblower, right? So there's still a little bit of discretion there with whether or not the agency wants to take this up. And then also whether or not Department of Homeland Security thinks that it's sufficient enough for them to grant deferred action to the individuals who have a complaint. So we have some hurdles, but now because there is this process in place, it makes that otherwise huge hurdle not look so big to individuals.
We have a question in the chat. I'm going to actually defer this to you two. It says, does this protection extend to an individual's family members? Or I'm assuming do they get deferred action as well?
Unfortunately, no. Or fortunately, I don't know whose side you're on, but no, it's for the individual.
Great question. And I would encourage folks to also ask questions throughout the chat. We'd love for this to be interactive and for us to answer your questions to the extent we can live. So what are some of the common claims an employee might bring? I know I listed a bunch of them. Again, there's so much that an employee can raise concerns about because there's so much that an employer in California specifically has to comply with. So again, what can an employer do is to make sure that you're following the law. And I would say some of the big ticket items are your wage and hour laws, is following those, making sure that and I would have to say, work with employment counsel or an experienced HR person to make sure that you're up to date on wage and hour laws. And wage and hour laws are all the laws that relate to the pay, someone's pay and timekeeping. So making sure you're paying them, the right minimum wage, making sure you're calculating overtime correctly. That's now changed. It needs to be based on the regular rate of pay, which is a legal term of art. It's not someone's just base pay. You want to make sure you're giving someone their meal periods and rest breaks, which again are very specific under California law, how long they need to be, when they need to be taken, and what happens if you don't allow someone to get those meal periods and rest breaks in a timely manner. So that's pretty much it for wage and hour claims. And that's another big bucket would be the unsafe working conditions. That's, the OSHA stuff that we've talked about. Making sure that you've conducted your own health and safety walkthrough of your workplace to make sure that you've got all the up-to-date signs, training, certifications, like if you have forklifts, like making sure, everybody's adequately trained and licensed to lift those or do those types of work. So making sure you have safe working conditions. But again, the employee doesn't necessarily have to be right when they make these allegations. I mean, I would argue that they have to be a good faith complaint, but they could arguably blow the whistle on something that they reasonably believe is unsafe. And that could be enough to open an investigation into your workplace, which could take several months to a year, which could, result in them getting deferred action under this program. So you'd want to kind of head all these issues off by just, doing audits of your own wage and hour practices. You're making sure you have OSHA and Cal OSHA compliance. And I know those organizations, at least for Cal OSHA and OSHA, can send somebody out there to help you, mitigate against some of these risks. Another big claim that we see a lot, category of claims are EEO claims, equal employment opportunity claims. And those are, again, claims based on a protected class or characteristic. So somebody could raise a complaint or be blowing the whistle about what they believe to be a pattern and practice of gender discrimination, age discrimination. And then now, it could be discrimination based on gender identity and gender expression. So things like that, that leave you as the employer vulnerable to a claim. Again, someone could be motivated to bring one of these claims because of this program. So, first and foremost, just make sure you're taking a look at your policies and your procedures and what's going on at your workplace on a day-to-day level.
Now, Hieu, I have a quick question before we move on. Do the employees have to be classified as employees, or can they be, quote unquote, contractors who are misclassified?
I think technically they could be contractors who are misclassified. And I think if you've been in California and paying attention to the whole misclassification issue that's come up in the law, a person who believes they're misclassified, meaning the employer and this person has characterized their relationship as an independent contractor status. If a person were to file a claim with the labor commissioner and say, hey, I was misclassified, that technically is a wage and hour claim. They could say, I should have been classified as an employee. I am now entitled to minimum wage, overtime, meal periods, and rest breaks. And that could result in a whistleblower complaint that could result in deferred action under this program. That's a great question, Josune. So an employer should also look at their current independent contractor agreements, if there are any, or any engagements that they have, and really look to see if those individuals are properly classified under the law and if they should really be an employee.
So these labor agencies will take a look at any of these claims and investigate as necessary, right? So it doesn't just have to be an employee.
Correct. Anybody can go to one of these labor agencies.
I mean, not to scare y'all, just
Yeah, sorry to bloom so early.
Yeah. That sounded very doomed.
Right. And so what should employers do, right? You want to make sure that you're complying with hiring individuals who are authorized to work. So what does that mean? Well, it means making sure that as an employer, you are completing the Form I-9 employment eligibility verification for every new hire, as well as re-verifying the work authorization of the individuals who have temporary work authorization that expires. And there's a re-verification process for that to make sure that the individual is still working with valid status, employment status. One of the other things that we've been advocating is for those companies who want to participate in E-Verify to enroll in E-Verify. And if company is already enrolled in E-Verify, to make sure that you're compliant with the E-Verify rules and requirements. E-Verify has been a hot ticket recently with the Florida law that was just signed, which is a lot, requiring employers in Florida that have 25 or more employees to enroll in E-Verify, as well as other situations where they may be required to enroll in E-Verify. So that is something that if you as an employer are operating in Florida, you would want to reach out to your counsel to see if that is applicable to you. So you're not in trouble with Florida law. Also with the I-9 situation, for those of you in human resources, we are all anxiously awaiting the new version of the Form I-9, which, we're thinking it might just drop right around the time of the immigration lawyers annual conference. Like so many things usually come about when we're all together. The government seems to take action then, which will be later this June. But we could have that Form I-9 anywhere between now and the end of the summer. We don't have a definitive timeline for when they're going to release that new Form I-9. We do know that there's also another regulation that's being looked at by the government, by multiple agencies, to determine if they will allow for virtual inspection of I-9 documents. And by virtual remote, it means not being physically in the same place as the employee when the document is presented by the employee for their identity and work authorization. So we're hoping that the government does allow in the future some type of virtual review of the identity and work authorization documents for employers to complete the I-9 process. But until that time, we are in a situation where there has to be a physical review of the documents. A lot of you may be aware of the COVID-19 flexibilities that allowed for virtual or remote review of those documents for employees that were working remotely because of COVID-19 flexibilities. Once somebody came back to work regularly, or their remote position due to COVID now turned into a remote position just because it's better to be remote, there has to be a physical inspection of the individual's documents. That needs to be completed by August 30th of this year. The ability to use the virtual or remote inspection of the documents for I-9 completion will expire July 31st. And then the physical inspection will need to be done by August 30th. So a word of advice here is, as an employer, it would be, recommended to start making sure that you're doing your review physically. That could be either at the company, with a company representative, or if an individual is remote and you don't have a worksite location close by, maybe using a designated or authorized representative to assist the employer. So those are things to be aware of with making sure that you're hiring authorized workers. One of the things with the whole I-9 process is there's this section of the Department of Justice that not a lot of people really pay attention to, but they have been very active recently, and they are hiring more attorneys, so they will be even more active. That's the Immigrant and Employee Rights section of the Department of Justice. They're within the civil rights area. They look at whether or not there's discrimination in the I-9 process. And that would be the recruiting, the hiring, et cetera. So they are looking to see, what's being done. Individuals can file complaints with IER if they have been, required by employers to present certain documents, or if their documents have been refused. So that's another avenue, for complaints to be filed, but also a way for employers to make sure that they're completing the I-9 process the way it should be. I know you have a ton of things on your plate that you have to think about in terms of compliance, but I-9, which is at the very beginning of that employment relationship, is incredibly important. And that's one of the things that you want to look into. And as I mentioned, E-Verify, which allows, the government to actually verify the documents that are presented by the individual. Those documents are run through the SSA database and Department of Homeland Security database. So an employer will be told if that individual's work authorization is or is not compliant. So it allows you to, in a way, help protect the company rather than continuing to hire somebody and get into trouble with that in the future. If they're not authorized to work, you might be able to find out sooner rather than later. So that's what we have on the immigration side. How about you, Hieu, with the labor laws?
I do have a couple follow-up questions for you, Kimberly, where you said that, and Josune, you can take this one too, whoever wants to answer it. but you mentioned the July 30th deadline and then the August 30th deadline for actual compliance. So if I'm an employer and I have a current employee now and I hired them during the pandemic and I checked their, their documentations and their authorization to work in the United States remotely, they held up their passport or their social security card to, the Zoom window, because I know that's what a lot of my clients did. Do they have to do anything now, like as a physical follow-up to check those documents? Or are you just talking about only new people we hire from now on?
That's a good question. If the individual's documents were reviewed virtually, they now need to be reviewed in person. So the individual will have to either come in and complete that with a company representative at the work site or with a designated representative. But they will have to provide their actual documents and have that person hold them in their hand to make sure that they're real. They don't have to provide the same exact documents that they provided initially, right? That document could be expired, but the individual has that choice to present a List A document or a List B and List C document. And it doesn't have to be exactly what they provided before.
Right.
So that's one of the things that's helpful, right? Because we know people may have lost their documents or they've expired, and the government's trying to make it easier for them to be able to do that physical inspection.
Thank you.
Mhm.
So looking at what employers should do to take action to make sure they're complying with California or even, other states' labor laws. My recommendation is to start with an audit of what you're doing now. And I know that can sound daunting, but just take it piecemeal. So, going through your hiring process and make sure you're complying with all the hiring laws and documentation that you have to do, the I-9 verification being one of them. But, in California, you have to give a number of documents at the time you hire somebody to making sure you're doing that correctly. Then they're employed with you. Do an audit and make sure you're paying your employees correctly and you're following the appropriate timekeeping policies. So that would be looking at payroll records. So doing an audit there. And again, it can seem overwhelming, but if you take it piecemeal, you'll be fine. Or you could work with, again, outside counsel or an experienced HR person. It's money well spent, right? To avoid the risk of what could happen if you get a claim. So looking at payroll records, timekeeping policies, and then also from there, say you're paying everybody correctly. Great. Are they classified correctly? So that's looking at their job descriptions to make sure that did you appropriately classify them as hourly non-exempt, where they'd be subject to overtime pay and all these meal periods and rest breaks, or if they're properly classified as exempt. People always like to say, well, they're salaried, they're fine. They don't need to be, and they do, they're high level. But there's actually very strict laws in California and under the federal statutes as to what actually makes somebody exempt. And then are you paying them correctly the amount? There's a certain salary threshold in order for someone to be properly classified as exempt. So doing that. Then when you let somebody go, making sure, you're letting them go. There's again, a number of required documents that you have to give them about unemployment benefits, giving them COBRA information. So all of that. So doing an audit of the life cycle, I call, of an employee, to make sure you're in compliance. Also make sure your employee handbooks are updated, which is super important, because that is what's always Exhibit A in a lawsuit against you, either for you or, that Exhibit A, that handbook is in your favor, or it's going to hurt you badly. So if your employee handbook doesn't have the right policies, then, we'll have to talk about that offline, but you definitely want to make sure those are updated if they haven't been updated in a while. So that's what I would recommend to comply with to labor laws. Oh, and then I know I mentioned OSHA earlier, is you could contact, Cal OSHA or OSHA, and they will send somebody out there to do a walkthrough with you. They want you to have a safe workplace. So just making sure you're doing that. And if you're in a specialized employment industry like agriculture, there's a whole host of things that you need to comply with to keep employees safe. Similarly, if you're dealing with chemicals, etc. So just make sure there's no harm in taking a proactive measure. It's when you wait, you get a complaint, and then the agencies come out, they're really gonna, ding you on stuff. There's a question from the same person. It's a two-part question in the Q&A, and it asks, if you are an employer and you are working and partnering with a staffing agency, so they're not technically your employee, but the staffing agency's person whom they staff with you, what if they're undocumented and a non-citizen and they raise a complaint? I would argue technically that they would be allowed are eligible for deferred action under this program. And I liken it to a lot of the labor laws, even though they're not your employee, if you're not, giving them the appropriate meal periods and rest breaks, et cetera. And even though you're not paying them, if they come on your property because of the staffing agency, you're still jointly liable as a joint employer. And so they're going to be blowing the whistle on you, and because they work at your work site. So arguably, I would think that they're eligible for deferred action. I'm not sure if Josune and Kimberly have, different opinions.
I would agree with that. There isn't anything in the guidelines that would prohibit it.
Yeah, or exempt it. It's all, case by case. They're very clear about that. They're clear that they can take deferred action away at any moment. But I think under those facts, they would look at, the public policy behind it, and they do want to encourage individuals to report any wrongdoing, right? And I don't think that they're going to defer staffing companies, from, or at least individuals working at staffing companies from being able to report a wrongdoing.
Yep. And that used to happen all the time, right? Where an employer could say, well, these aren't my employees. This is the staffing agency's employees. So if the staffing agency didn't pay you correctly, that's on them. And that's why we have joint employer liability, is you may not be the employer of record, but you're still in trouble for who you're doing business with.
Good times. So we're going to open it up if there are any additional questions for us. I mean, what we're talking about right now in a general sort of way is do some spring cleaning. We only have, 21 days left of spring. So do some spring cleaning and then take a break over the summer, or maybe not, because the I-9s are going to be due this summer. So anything that you want to get started on is probably a good time, especially if you did any kind of remote or virtual I-9 inspection. Don't want any of that getting up to a labor agency that can help with a complaint.
And please reach out to any of us. We're happy to answer questions about this program and ways in which you could avoid this risk to the extent possible, how you could comply with immigration and labor laws.
Happy to help out. Thanks, everyone.